Okay, I think I finally got this thing up and running. Apparently, you can write a title, but I couldn't figure that part out yet. And now the Facebook interface is doing things. Um, so I'm not actually waiting for people to show up, but I'm trying to figure it out. So, wait a minute. I think I see something. All right. So again, I'm DK Williams, and I understand that this will just stay up afterwards. So even if we get no live participants, oh, there's somebody. Awesome. Not sure who that is. Um, but since this will stay up, I understand. So people can look at it whenever they want to, if they're so inclined. So there are charges in the Breonna Taylor case that came out today. And I saw the Kentucky Attorney General, last name is Cameron. I saw him on his press conference. I think it went about 40 minutes. He gave a good press conference. And the result of it is that the charges at this point, and who knows, the feds might come up with something later, but as of now, only one of the three officers that fired shots in Breonna Taylor's apartment is charged. And he's not even charged with anything to do with her death. He's charged with wanton endangerment. And apparently that's because he fired his weapon in such a way that that wasn't justified, but not the ones that shot Breonna. Apparently he fired into another apartment, or somehow his shots went into another apartment, and that's what he's been charged with. Nothing to do with Breonna Taylor's death. The attorney general said that the other shots, the shots that killed Breonna, were justified, and so the police were justified in shooting because there was a shot fired at them. We'll talk about that, to some degree. And I'm not sure if you guys can um, do comments or not. Um, Again, I'm figuring this stuff out. This is like a trial run. We'll see what we can do with it. If you can if you can comment, let me know. Try it, and I'll see if I can see it. If not, let me know later, and I'll try to figure it out. But I want to talk about grand juries for a moment, because what prosecutors will do sometimes is use a grand jury as a way to protect themselves politically. You've probably heard of the saying, you can indict a ham sandwich. Quick aside on that, my law school softball team that traveled to the University of Virginia. Galen, good. You can't comment. Awesome. We had a softball team. We traveled to a big law school softball tournament at UVA, not too far from Chapel Hill. We drove up there. And the nickname of our softball team, and we had jerseys made up, and it was Ham Sandwich. We picked that because you can indict a ham sandwich. That was the joke. But that basically is a reference to how much power the prosecutor has in a grand jury, because it's completely secret, right? Nobody is supposed to say anything about what happened during the grand jury. And only the prosecutors show evidence, present evidence to the grand jury. So if person X is being investigated, prosecutors are going to present whatever evidence they have against person X for whatever it is that person might have done. Person X doesn't get to present any defense. Not how a grand jury works. It's not the point of a grand jury. Grand jury is supposed to just decide if there is enough evidence to charge person X with something. And if the grand jury doesn't do it, if the grand jury says, no, there's not enough evidence, then the DA, or the prosecutor, in this case it was the attorney general, because of the circumstances of the shooting, because there's a potential conflict, if not an actual conflict, if the Louisville prosecutor, whatever county that is investigating police officers that he talks to all the time and his office has to use in criminal prosecutions, then there's a conflict of interest there. So they brought in the attorney general of the state and his office to present this evidence to the grand jury. And what will happen, or what can happen, is the grand jury can be guided, and is absolutely guided by the prosecution, because it's secret. And so if the grand jury is told by the prosecutor, okay, here's the evidence, Probably not enough. The grand jury is going to hear that, right? The grand jury is going to hear whatever argument the prosecutor has to say, and it's secret. It's not ever supposed to come out. Limited exceptions. So, in a lot of these police shooting cases, what will happen is the prosecutor says, "Oh, we presented the evidence to the grand jury. It's up to them," but they don't really want the grand jury to charge the police officer. If that's the case, maybe it's not, but it can be the case. And then if the grand jury comes back and says no true bill, that's the legal terminology for saying we're not going to charge the police officer, then the DA or the prosecutor can say, it wasn't me. I didn't make that decision. The grand jury did. So it is a good way, can be a good way for a prosecutor who are all politicians. DAs are elected, attorney generals are elected, at least at the state level. It's a way to protect themselves. So just keep that in mind. I have no idea to the extent that happened here, but 3 of the officers, 2 of them weren't charged with anything, and 1 was charged with a wanton endangerment Class D felony for basically firing recklessly. Judge Napolitano, just a little while ago, compared it to accidentally hitting someone with a golf club. Right? You're being reckless. You're wantonly endangering other people. So, and there are some protests going on in Louisville now. We'll see what happens with those. Hope there's no violence and no burning of buildings, especially private buildings that people had nothing to do with it. So Brett Hankinson is the police officer who was charged. 3 felony accounts of wanton endangerment. He's out on, or the bail has been set for $15,000. As of now, I don't know if he's reported, but that's what the bail is going to be. So he will get out once he shows up and turns himself in. That's probably what will happen. Class D felonies in Kentucky are a maximum of 1 to 5 years in prison per count. Theoretically, if he's convicted on all 3, he could get 15 years. That's not going to happen. As a practical matter, he wouldn't get any time, most likely, maybe some probation. So, and if he's convicted on all 3, whatever he gets will be run concurrently at the same time, most likely. So he's probably not going to do any jail time, even if he's convicted of this. And of course, there's still the possibility that the feds might come in and charge him with something, but that's not happened yet, and it may not. The biggest problem, from my perspective here, is the existence of no-knock warrants, which is what the Louisville police had here. Now, they're saying they announced themselves. I'll talk about that in a second. But the warrant allowed them not to. And the entire reason no-knock warrants exist is because of the drug war. Cops became concerned that, hey, if we knock and say, hey, we're here to have, we got a warrant, knock, 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 that people with drugs had time to run and flush it or get rid of it somehow. So the no-knock warrant, like, we can bust in, we can get the drugs before they can flush it. Now, what they can do, notwithstanding the immorality of the war on drugs, is they can turn off the water to the house before they go in, or the building, or whatever it is. Therefore, they can get the drugs even if they're flushed. But notwithstanding that, that's the idea behind the no-knock warrant, is because of drugs. And they didn't want people with drugs to be able to get rid of them, flush them. They also talk about violence. They could be subject to violence. Although I don't see how surprising people makes it less violent. It makes it less likely to be shot, which is what happened here. So this warrant was executed at 12:40 in the morning on March 13th of this year. And I see you, Galen, about charged with being a bad shot. Charged with firing it without regard to where he was firing it. And apparently it did go in the apartment next door where there was a pregnant woman. Nobody got hurt, but they have filed a complaint against the police department for that as well. While talking about civil complaints, Breonna's family filed a wrongful death lawsuit against the city of Louisville. My understanding is that it was settled for $12 million. That's the number I saw in the news. So that's the civil liability. When you knock, even if you do knock, which the police say they knocked and announced themselves, police, that doesn't, just saying that, even if it's true, isn't very helpful. Mike, we got you. And thank you for joining us. If the police, they got multiple guys out there and they've got a battering ram so they can break down the door, right? If they just go, police, bam, that's a knock and announce. That's useless, right? How do you know it's the police? They just said they're the police. You don't know it. So even if they did knock and announce, how did they do it? And Breonna's boyfriend, who was there, said that they were asleep. They'd been watching a movie. They fell asleep. They heard people knocking, but they didn't know who it was. And Kenneth Walker is the boyfriend. Says they didn't say they were police. And out of the multiple people in this police department, or I'm sorry, in the apartment living in this building, one of the reporters at the Kentucky Attorney General's press conference today said that, reporters had been all around and asked everybody there if they had heard any, the police announce themselves. Well, apparently one person did. Nobody else did. So that's the basis for the independent verification that Kentucky Attorney General said, we have one independent person. Well, how strong is that? How strong is it? That person can testify. If other people didn't hear it, were they asleep? Where were they? What position could they have been to hear it? But just the fact that they knocked and announced doesn't mean it's all that helpful, right? So there's no dispute that they had a no-knock warrant. Police said they did knock and announce. Again, how? Do they just, bam, come in with the police? If they did, that's meaningless, right? It doesn't help defuse the situation when you're bursting into somebody's apartment at 12:40 and trying to serve a warrant for drugs. Again, this wasn't for violent activity. It was for drugs. Just another problem with the war on drugs and the no-knock warrants, which were a product of the war on drugs. So that has to end. No-knock warrants have to end. Louisville has since changed their rules, so they're not going to do it anymore. They should be outlawed everywhere. If there's a person you need to get because you've got a warrant for them or for something, you can knock on the door, see if they come and answer it. If they don't, you can wait for them. Because bursting into a residence or any building with people in it is creating a violent situation. Now the state has become the one that is initiating the force. And you think back to David Koresh, right? The ATF knew that he left that compound. He jogged, he walked. They could have waited for him to get him, but instead they initiated force, and we know what happened there. So this initiation of force to serve a warrant is bad policy, and it should be illegal. But as of now, it's not. You should have to wait till somebody comes out if you've got a warrant for them. They got to come out at some point, right? And if they decide to stay in the house the rest of their lives, well, they're locked up anyway. The AG said that the police officers were justified because the boyfriend, Kenneth Walker, did fire a shot at them. I mean, people are bursting down the door, so he fired a shot. Perfectly legit. He's not charged with anything, Kenneth Walker, even though he fired and did hit a cop in the leg. He hasn't been charged with anything. So he was justified because people are bursting through his door, or that he wasn't a resident there, but he was staying there with his girlfriend. Fired a shot, and he's not charged with anything because I think it is justifiable. But the police officers weren't either because they had a warrant and they returned fire and they killed Breonna. Now, apparently that she wasn't asleep on the couch when she was shot, from what I've read, and the Louisville Courier-Tribune has got a good running tally of facts and fact-checking and things that are right and things that are wrong. That they both did get up when they were awakened by the noise of people banging the door down. So she was shot and killed in the hallway at just after 12:40 in the morning. So law enforcement shouldn't be able to break into a resident unless there's violence going on in there, right? Unless they're in hot pursuit of a murderer, or they have reason to believe something bad, violent is going on in there right now, and they need to go in there, which is not the case here, and it's not the case in almost all of these drug warrants. They just want to catch the guys with drugs. All right, so, and the person that they were looking for wasn't there, and Breonna Taylor had nothing to do with drugs, no drug history whatsoever. Neither did her boyfriend, is my understanding. There was somebody who said that there were packages delivered to that address. What the hell? Somebody said something? I mean, I know they got all these informants. Yeah, to me, that's very, very weak. Very weak. And if somebody says drugs were delivered, dropped off at this address. Well, stake it out. Or better yet, that's in the war on drugs, and it doesn't matter anyway. We don't have police starting these violent altercations. So what kind of and the person wasn't there that they were looking to arrest. So what kind of intelligence are they basing their barging in? They're violently breaking down the door of a residence. That's bad intelligence. And it's another reason that to make sure that if we're going to do something like this, it should be for violence. Trying to catch someone who is violent, not someone who might have had a package addressed there, or find somebody who sent a package because there's drugs in it. Breaking down the doors of a residence when the person you're looking for isn't there, that's inexcusable. That should not be tolerated. And let's just do away with this type of warrant, and we don't have to worry about the mistakes, the bad intelligence anymore. All right. Oh, and the police officers were apparently in plain clothes as well. These were detectives and sergeant, I believe. So they're not even in uniform. So how do you know that they're police officers? Just because they said it, right? Anybody can say they're a police officer. All right. So it looks like I've been going on for a while. This was a experiment. Just wanted to get some of that out there after watching the Attorney General speak during his press conference and seeing some other commentators on the issue. So appreciate you guys hanging in there, and I might do this some more. Let me know, and thank you. Live free. Go to the website. Check me out. The regular podcast, right? The Law with DK Williams. There's a link there. I think there should be a link there for the Twitter, my Twitter account for the podcast, The Law DKW, and you will be kept up to date on whenever a new podcast comes out or any other interesting legal news happens. Freedom is dangerous, my friends. Live dangerously.